In late January of 2026, a federal judge in the Southern District of New York unsealed a wave of documents in the lawsuit between Blake Lively, Justin Baldoni, and others. This includes text messages between Blake Lively and Taylor Swift that had everybody talking. But here's the part that most people skipped. They were made public due to a 73-page motion triggering their unsealing. And no wonder they skipped it. It's 73 pages. But it lays out Wayfarer's argument for why they believe this case shouldn't go to trial. The defense claims that early on in the production of It Ends With Us, Baldoni and Wayfarer address any issues Lively raised, and they say that the later conflict was about creative control and publicity, and that none of it meets the legal standards for harassment or retaliation. So instead of relying on summaries or headlines, we're going to look at the actual document. Am I going to read all 73 pages to you? No. We're going to start with the statement of facts. That's Wayfarer's version of what happened, and honestly, as far as the document goes, it's where all of the chaos lives. And after that, I'll summarize the legal arguments portion so you can see what exactly they asked the judge to do. Before we dive in, please like and subscribe and hit the notification bell if you prefer fact-based content versus interpretation and spin. Quick recap, It Ends With Us came out in August of 2024, and almost immediately, the behind-the-scenes drama started leaking out. Creative control fights, on-set behavior complaints, and enough anonymous sources to staff their own production. Then in December of 2024, the New York Times dropped its big investigative piece, which kicked off a whole chain reaction of lawsuits. After Lively's initial lawsuit, Baldoni sued the Times and others for defamation, and a few other related cases popped up and quietly exited stage left. But Lively's lawsuit against Wayfarer, Baldoni, and others is the one still very much alive, with a trial set this year. And that brings us to this motion, which is document 1242, which tells you exactly how sprawling this case has become. The motion doesn't mention the unsealed documents, and that's because the motion is what caused them to be unsealed to the text, emails, and filings that came out late January. Statement of facts. Baldoni is an actor, director, producer, and author. He has published books and a podcast with experience in addressing gender issues, all aimed at a predominantly male audience. In 2019, he obtained the rights to produce It Ends With Us, and Baldoni's production company, Wayfarer, specializes in films designed to promote social change. They initiated work alongside Sony, with Baldoni as the director and lead male actor. Because the story focuses on DV, Baldoni and Wayfarer partnered with an organization focused on ending DV and intimate partner violence, and agreed to contribute a portion of the film's proceeds. The parties agreed to center the film's publicity on these serious themes. A. Lively chose to take a lead role in a film with adult themes. In December of 2022, years into the development, Lively, a well-known actor, was cast as the female lead. She had never read the book. She understood, nevertheless, based on the script and before she accepted the role, that the film would include intimate content and address DV. Prior to filming, Lively reviewed notes from a female Sony exec stating that the audience was expecting something grown-up and sexy with real heat. B. Lively worked as an independent contractor, but no contract was ever signed. The parties never executed any contract regarding her role. Negotiations began in December of 2022 with It Ends With Us Movie LLC, an entity Wayfarer Studios formed, and Blakel, a loan-out company lending Lively to perform in the film. An offer letter set forth financial terms, promised Lively a $1.75 million fee plus various bonuses, but did not contain any terms regarding harassment. The parties also worked out a separate agreement to include other material terms, IEWUM. I'm going to call it the movie company. So IEWUM, aka the movie company, their obligations under the offer letter were expressly subject to a full execution of an agreement in a form acceptable to all parties. The Movie Productions Council circulated a draft of the agreement between the two entities. The draft stated conditions including the full execution of the agreement and receipt of an executed document known as an inducement. It also had a merger clause specifying that it constituted the entire agreement between all parties. Also, a provision prohibiting special or consequential damages and other standard terms, including one stating there would be no actionable breach for any conduct unless notice was provided and cure not effected within 30 days. The same or similar terms endured throughout the drafting process. As work proceeded on the film, payments were made pursuant to the offer letter. The parties continued to negotiate on the terms of the long-form ALA into July of 24, but Lively herself continued withholding her signature to avoid being bound. C. From the outset, Lively sought to increase control over the film. Although recruited to act in the film, Lively immediately assumed an active role in production and in developing the film's script, even before filming began. Among other things, she provided Baldoni with a rewrite of the rooftop scene, in which Baldoni's character meets Lively's for the first time. She explained that her version of the scene increased the tension. It retained a line from the book, one that Baldoni's character says to Lively's, "I want to F you," and in messages to Baldoni, Lively referred to her draft as featuring flirty and yummy ball busting. I swear, we all live in our own bubbles, but the way they talk is just so odd to me. It's flirty and yummy and ball busting. Anyway, Lively took special steps to convince Baldoni to accept her version. She asked a friend, the world-famous musician Taylor Swift, to drop by when Baldoni, who she called, quote, "this doofus director of my movie and a clown," would be meeting Lively at her apartment. And after the meeting, Lively asked Swift to promote her version of the scene, even though she hadn't read the script or really been involved. After the meeting, Baldoni told Lively he would gladly accept her revisions, even without urging from Swift or Lively's famous husband, the actor Ryan Reynolds. Lively had since disclosed that Reynolds, not she, rewrote the scene. This episode, which occurred even before filming began, was the first of a series in which Lively relied on her Hollywood friends to increase control over the film while denigrating Baldoni to them all the way. Before filming began, Lively took other steps to influence the direction of and take control of the film. At her request, Wayfarer abandoned plans to shoot the movie in Boston, where the novel takes place, instead relocating to New Jersey, which is near Lively's home. Wayfarer also agreed to change the start date and to schedule to accommodate Lively's other professional and personal commitments. D. Lively raised concerns about her physical appearance. Having recently given birth, she expressed concern to Baldoni and others that she was not in top shape and wanted to look her best for the film. When Lively asked Baldoni to push the body scenes to the end of the filming schedule, he responded kindly, quote, "I want you to know you will look amazing. Anything you are insecure about, we will talk through and get creative together and make you comfortable. I just don't want you to stress about your body. It's the last thing you need." Meanwhile, Lively raised the same concerns to her agent, noting she was working out twice a day, 4 hours a day, because she wanted to be all set up for success. Lively communicated her frank awareness that the film was intended to achieve a certain imagery. She told her agent, quote, "The sexiness in this film, and the marketing, I'm sure, is critical to its success." Lively was frank with Baldoni. "I know my job here, as woke as we both are and work to be. This movie requires an aesthetic. It's part of the job that we both excitedly signed up for." She also added, "I don't shy away from it because it's not problematic." E. Wayfarer, IEWUM, and Baldoni took steps to create a safe set. Wayfarer had a set of industry standard policies and procedures in place to prevent harassment, discrimination, and retaliation. Its employee handbook prohibits this conduct and encourages employees to report violations. Wayfarer had an HR department with dedicated staff, held an anti-discrimination training, also had worker safety hotlines on its daily call sheets. Lively benefited from other protections as well. The offer letter provided that she would not perform any nudity or, I think it's supposed to say simulated, not stimulated, simulated intimate scenes without her prior consent and without negotiation and execution of a formal nudity writer. In April of 23, before filming began, The movie company hired an intimacy coordinator for the film, and Lively was given the opportunity to meet with her a month before filming began, but declined. Before shooting began, the coordinator suggested details and clarifications. She also spoke with Lively about boundaries, and when Lively expressed reservations about intimate scenes, Baldoni volunteered to keep focus on his body so scenes could be choreographed in a way that kept Lively's clothes on as much as possible. Prior to shooting, Lively and Baldoni were both provided writers detailing their consent and boundaries concerning intimate scenes. F. In the first phase of filming, Lively did not film any intimate scenes, but voiced objections to certain behavior. Filming began in May of 23. It stopped about a month later on June 14th due to strikes by Writers Guild of America and SAG-AFTRA. None of Lively's scenes were rehearsed or filmed during this period. However, all incidents Lively now characterizes as compromising a hostile work environment occurred prior to or during this first phase. Lively's stated concerns, even if true, all involve incidents of relatively low-level or innocuous behavior that, considered separately or together, fall far short of actionable discrimination or harassment. For instance, Lively claims Baldoni described his genitalia in their first meeting before she had agreed to join the film. This is a hyperbolic lawyer spin on what actually happened. During the meeting, Lively raised the topic of circumcision. She was pregnant and noted she and her husband were considering the issue. Baldoni responded by noting that it's one that he and his wife also grappled with, because his parents had chosen to circumcise him. Such a statement obviously does not qualify as justification to bring any claim to court. Indeed, Lively herself seemed unfazed. She raised the subject, but didn't complain, and after the meeting, her husband sent Baldoni an effusive message saying both he and Lively were big fans of his. Lively also accuses Baldoni of fat-shaming. This allegation is based on a single instance in which Baldoni, who had chronic back problems, anticipated a scene in which he would have to lift Lively up. He privately asked a physical trainer that he had consulted with, who trained Lively, about her weight. He did so discreetly outside the workplace and Lively's hearing. But even if his inquiry was, as Lively now portrays it, a sly criticism, any petty slight that might have been arisen when the trainer on his own initiative repeated the comment to Lively is simply too trivial to constitute harassment. That is a messy trainer, man. Lively further accuses Baldoni of adding gratuitous content to the script before filming began. The evidence shows that scenes were added with the encouragement of a female Sony executive to align with the explicit female-authored book on which the film was based. Baldoni asked the intimacy coordinator to review them with Lively. To the extent Lively objected, scenes were revised or removed. Moreover, Lively herself wrote scenes to boost their sexual vibe. Lively claims Baldoni improperly used the word sexy to refer to her wardrobe, and on one occasion, that of another actor, and that at one point he complimented Lively's own personal low-cut outfit. Such passing, sporadic comments, while perhaps still advised, are not outrageously offensive in an environment where professionals are working closely together to make a deliberately sexually charged film. Lively also asserts Baldoni at times alluded to his own experiences with intimacy. Again, such exchanges are hardly surprising, given that Lively and Baldoni were collaborating and communicating daily about how best to portray various themes. Lively also claims Wayfarer's CEO and one of the film's producers, Heath, momentarily glanced at her naked upper body after she permitted him to come into her trailer while she was having body makeup removed. Lively says she instructed Heath not to look at her, but at some point during their brief conversation, he glanced at her through a mirror. Whatever fleeting mishap may or may not have occurred, it is being characterized as sinister only in retrospect. At the time, Lively said, "I know you weren't trying to cop a look." Lively also objected to being shown a video image relating to Heath's wife's home birth, incorrectly believing it was porn. A female Sony exec testified that Lively expressed displeasure to her. The exec reviewed the same image and concluded there was no need to take further action because Lively's reaction was a result of a misunderstanding or a mistake. The film includes an important scene between Lively and Baldoni's characters surrounding the birth of their child, and the two of them had discussed the scene before Heath shared the image. Lively includes an assortment of other objections in her complaint, including that she contracted COVID on set, as well as that after Lively told Baldoni she had never seen porn, he shared the fact with others. At one point, Baldoni shared a personal story about being pushed past his own consent boundaries, an experience he discussed publicly during his published books, and that there was too much hugging on set. G. Lively's objections were addressed before and during the filming hiatus. Although Lively's description of events is disputed, what isn't is that Lively's objections were resolved as soon as they were raised. She not only chose not to file any formal complaint, but also instead told another cast member at the time she preferred to personally tackle them. Consistent with that approach, after Lively and husband chastised Baldoni for inquiring about her weight, the issue did not recur. Lively objected to certain scenes, and Baldoni revised or eliminated them. 5 months after filming had stopped due to strikes, Lively, through her entertainment attorney, sent a list of protections in regards to future filming. Lively's attorney said that a signed agreement to abide by the protections would suffice in lieu of a more formal HR process. Though her lawyer said she reserved all legal rights, the requested protections largely replicated protections that were already in place. Other protections implicated conduct that Lively herself had engaged in during the earlier phase of filming, like improvising kissing in scenes, commenting on her own physical appearance or that of others, and hugging cast members. On January 4th, Lively held a production meeting at her apartment. Lively and her husband hijacked it to berate Baldoni, as well as Heath. Lively read a list of grievances, and it included, in addition to the things described above, a demand that Baldoni not speak to her dead father, mention his own religious beliefs, or have private multi-hour meetings in Lively's trailer where he's crying. Lively also demanded notice of COVID exposures on set. Then on January 19th, Heath, on behalf of the movie company, signed the protections as incorporated into a rider between the two entities. Lively refers to this document as a Contract Writer Agreement, or CRA. The CRA does not include any admission of improper conduct. It is forward-looking concerning behavior once filming resumes. H. The second phase of filming proceeded without incident. Filming resumed January 5th, 2024, and concluded February 9th. Lively raised no further objections and told another cast member that the set was professional. Whatever issues had been raised months before had been fully resolved. H. The second phase of filming proceeded without incident and concluded February 9th of 2024, and Lively raised no further objections and told another cast member that the set was professional. I. Lively used her famous friends and connections to take control of the film. Shortly after filming wrapped, Lively told Sony that she would not promote the film unless she was permitted to participate in the edit. Thereafter, she amassed enormous levels of control over the film. When she pushed back, she recruited famous friends, including the Damons, Affleck, Taylor Swift, disparaging Baldoni to them as a chaotic clown. Lively connived with Swift to use Swift's music to gain leverage over the trailer. Swift told Lively that it would give her more power over the film, and that's your ally, not Baldoni's. Lively agreed it was stupid for Baldoni to use the song because it cost him his only shot at having an appearance of an upper hand. And when Baldoni produced a cut of the film that scored higher, she still pushed the studio to rejecting it. And she wrote, "Colleen Hoover and I are declaring now this is the cut. It's done from my perspective and from Colleen's and from Taylor's." Lively also insisted changes, moving her own name up and removing Baldoni's film by credit altogether. In a letter to the Producers Guild of America from June of 2024, Lively would say to them, "I've produced every moment of this film from pre-production through production into post and now into marketing and worldwide release." And she would say, "So much has changed, the most significant being that the cut of the film that was selected to be released is my cut." Her long letter is not shy about listing numerous claimed accomplishments. And they say it's a remarkable document. She takes credit for things like determining the location of the film, putting forth the name of department heads, reshaping the creative of the production design for all key locations and characters, reshaping the creative of the costume design for all characters, significant rewrites of the script, firing the first assistant director, helping to block the staging of every scene, calling and leading meetings with department heads, studio and the distributor, and editing and re-editing. She also asserted that she was heavily involved in developing the marketing strategy, a claim backed by a Sony executive. J. Lively stirred up negative press about Baldoni in the film. Apparently not content to have wrestled directorial and editorial control from Baldoni, Lively set out to destroy his reputation and alienate him from the film. She and her husband, Reynolds, unfollowed Baldoni on social media, encouraging the press and fans to suspect a feud. Ryan Reynolds told famous friends that Baldoni belonged in jail. He told the executive chairman of WME, which is a talent agency, that Baldoni was a thoroughbred predatory fraudster. Lively told Hoover and another prominent author that Baldoni was a narcissist. Even Anna Wintour of Vogue magazine heard about how hard the production had been for Lively. She also took steps to exclude Baldoni from press associated with the film, including a high-profile event at the Hoover's Romance Book Convention. Unsurprisingly, the press took notice. Lively and Hoover discussed a post from a prominent gossip blog observing Baldoni's outcast status, but Lively wanted more, and on July 22nd, she told Sony that she would not attend the film's upcoming premiere if Baldoni was there, and ultimately he was allowed to attend, so long as he left the red carpet before Lively arrived, waited in a basement while she and her friends were photographed, and then watched the film in a separate theater. K. Baldoni and Wayfarer then hired a crisis management team. In this context, late July of 24, over a year after Lively's concerns had been resolved, and faced with a new set of concerns related to media and the coverage of the film, Baldoni and Wayfarer first entertained the concept of hiring a crisis PR team. As negative press intensified, the team agreed it would be a mistake to fan the flames and that they should not be doing anything proactive. Melissa Nathan's PR firm then met with Baldoni and Heath, and this is now in July of 2024, to discuss retaining the firm for crisis management. Wayfarer, in meetings, reiterated that it did not want to take any offensive steps and that Nathan would not be having any communications outside of their internal teams. In August of 24, TAG, which is the agency group, Nathan's PR firm, circulated the scenario planning document that has been much subject of Lively's ire. As the title suggests, the document simply laid out a menu of possible options rather than be an agreed-upon plan of action. Immediately after the premiere, numerous outlets published stories about a feud between Lively and Baldoni. This was because Lively's PR rep told press contacts that the whole cast isn't speaking with Baldoni, and that Lively and Baldoni watched the premiere from separate screening rooms, whereas instead, Baldoni's PR team distributed positive information and stories about Baldoni and worked to mitigate or minimize negative ones. Baldoni himself made numerous positive public statements about Lively. August 7th, Abel told Nathan that she was still waiting on a green light from Heath to put the social combat plan into motion. 2 days later, Wayfarer engaged Street Relations, which is Jed Wallace's firm, to monitor social media concerning Lively, Baldoni, and the film. Contrary to Lively's claims, Wallace testified his firm did not surreptitiously spread negative information about her and had no ability to do so. At the same time, Baldoni's team negotiated what they thought was a truce with Lively's PR team, in which neither party would engage with any media or do anything to interfere with the reception of the film. L. Lively suffered backlash. The attention commanded by Lively's star power and by the news of the purported feud was a double-edged sword. In August of 24, she experienced a massive outpouring of negative sentiment, but the undisputed evidence shows Lively's own missteps were a significant driver of that response. Several press outlets picked up, for example, on Lively's decision to cross-promote a serious film about DV with, among other things, her husband's summer superhero blockbuster, as well as her own hair care and beverage products, which I think it was alcoholic beverages or spirits. Lively privately acknowledged the marketing misstep days after the premiere and reached out to another cast member and advised, "We are looking to post resources for people experiencing DV." Sony execs observed the negative publicity had been driven by Lively's own ill-advised promotional strategies. Lively also came under fire for past missteps, including her decision to get married at a former slave plantation, old allegations that surfaced saying she was difficult to work with, and an interview in which she mockingly referred to the infertile interviewer as pregnant, the Little Bump interview, if anybody has seen it. Lively does not dispute any of these events actually occurred. She merely insinuates defendants had a role in bringing them to light. The evidence does not support her headline claims. After months of scorched earth discovery, backed up by a pounding drumbeat of almost daily motions to compel, Lively has been unable to identify an instance in which any defendant distributed or promoted any false story about her, even after subpoenaing dozens of content creators. Her interrogatory response summarized what she described as a highly orchestrated smear campaign, but reveals a surprising truth. Lively primarily objects to Baldoni's effort to defend himself, whether by promoting positive stories or trying to suppress negative ones. That's not retaliation. Indeed, Lively's own PR representatives took steps to kill negative stories about her, including stories she knew were true during this same period. Even when defendants contacted the press about Lively in August of 24, the efforts were far from a sophisticated internet takedown that Lively touted in the press. The few instances in which evidence suggests any defendant spoke to press about Lively at all involved truthful references about her actual conduct or that of her husband, or sharing opinions about the conduct. Lively's own PR rep confirmed that such communications are standard fare. In defending her own efforts to share negative information about Baldoni, Lively representative testified that it's okay to tell a reporter to include negative statements about someone if someone else in the press has already reported it. Lively also has long claimed defendants used a network of bots to bring her down. Contemporaneous documentary evidence shows Baldoni himself repeatedly confirmed with his PR people that they were not using bots or fake accounts. Nathan, in particular, assured him the backlash was organic and that she kind of did this to herself. Baldoni later discussed with Nathan that he had no intention to make Lively an outcast and was praying for her and her family. M. Lively and Reynolds smear Baldoni once again. Ironically, Lively's cry that Baldoni tried to bury her more accurately describes her own efforts to tar him. Beginning August 9, 2024, one day after Lively alleges the smear campaign began, Reynolds told his agent Lively's PR rep should fight back in any way necessary. 4 days later, Reynolds described Baldoni and his, quote, shitbag partner, presumably Heath, as predators and frauds to the PR agency, WME, to the executive chairman there, Whitesell. Whitesell reassured Reynolds that they won't rest until all studios, important buyers, etc., know the truth of all of it. Lively's PR rep, in turn, told one reporter that Baldoni was an animal and told another, "You forgot to link the fat-shaming and inappropriate kissing allegations." Lively then used a sham litigation to obtain the private messages of Baldoni's publicist, Abel, using a shell company as a bogus plaintiff. The company filed claims against an anonymous Doe defendant, and working behind the scenes with Abel's former employer, Stephanie Jones, invoked a New York State court subpoena power to obtain Wayfarer's confidential records from Abel's personal phone that Lively would not have otherwise been legally permitted to obtain. In December of 24, the New York Times published a 4,000-word article entitled "We Can Bury Anyone Inside a Hollywood Smear Machine," and it relied on documents Lively had obtained through the sham lawsuit, as well as an administrative complaint she filed the day prior. The article asserted Baldoni and Heath had violated Lively's physical boundaries and made inappropriate comments to her, and that then they instituted a retaliatory smear campaign. Weeks before the article came out, Swift gloated to Lively, quote, "I think this bitch," Baldoni, "knows something is coming because he's gotten out his tiny violin." Around the same time, Lively conveniently dropped her New York State court lawsuit, confirming it was not filed in good faith and only had been used as a ploy. And Lively initiated this litigation. She started it, is what they're saying. In December of 24, 18 months after the minor issues she raised were resolved, Lively launched this dispute with an administrative complaint and the fanfare of the New York Times headline. The behavior she previously regarded as not requiring any formal HR process now was presented by two large, sophisticated global law firms as harassments of the gravest kind. Baldoni's natural defensive effort after being sidelined by his own premiere to manage his own and his film's reputation by employing experienced PR professionals was now recast as retaliation against Lively for raising purported harassment concerns. Lively's numerous claims against numerous defendants cannot withstand scrutiny. Judgment should be entered for defendants on all claims. All right, think of this next part, argument portion, as Wayfarer's legal highlight reel. These are the arguments they're making to convince the judge that this case shouldn't even make it to trial. It's basically them saying, here's all the reasons we think that this whole thing should be wrapped up right now. Thanks so much. I'm going to walk through each argument and the way they present it in the motion, nice and quickly. We're going to do this quickly. The first argument is that Lively cannot prove any actionable harassment occurred, and it's broken into three parts, but the gist is pretty simple. Whatever happened was minor, it wasn't gender-based, and it was fully resolved, so it can't support a harassment claim. To the awkward comments and uncomfortable moment don't meet the legal standard definition for harassment. Then they also argue that being targeted because of your gender is a required element of this sort of case. And in their view, they frame it as her not liking the clumsy or tone-deaf interactions, understandably, but that they're not harassment. Even if they crossed a line, which they didn't, but that if they did, they addressed it immediately, it stopped, and she herself later described the set as perfectly professional and safe. Jenny Slate, another actor on the set, said that, quote, "I felt I had settled my issues on set and wanted to move on." So that's the first argument. The second is related to retaliation, saying that she cannot prove it. The gist here is that nothing Wayfarer did counts as adverse action, and that even if it did, it was caused by other things, like things she did before in the past, the antebellum wedding, or marketing alcohol during the time that you're marketing a movie about DV. Things. She wasn't fired, demoted, punished, or denied anything, and the only publicity efforts they acknowledged were, in their words, just offensive PR, not retaliation. Then they argue there's no causal link anyway. Too much time has passed, too many other things happened, there's no temporal proximity between her and the complaints she's making and the alleged smear campaign. In their framing, the PR response was about the public drama around the film, not about her earlier comments. Their third argument is that Lively was an independent contractor and not an employee. And this actually came up in another lawsuit I did. It's the one with Will Smith, because the person who was suing Will Smith wanted to establish that they were an employee, because in the state of California, employees have far more rights than independent contractors. At any regard, they're saying Lively was an independent contractor. They explain Title VII. They say that because she's an independent contractor, believes most of her employment-based claims automatically fail. They point out that no contract was ever signed, that she worked through her loan out company and that she controlled major aspects of her work. So essentially what she's saying is the fourth argument is Lively cannot prove a failure to investigate claim. And they say that there was nothing to fail to investigate because they did respond immediately to any of her concerns, and that even her own attorney said no formal HR process was needed. Their fifth argument is that Lively cannot prove aiding and abetting claims, or essentially, no one can be liable for aiding and abetting because there is no underlying harassment or retaliation to aid. Their logic is if the main claims fail, the secondary ones automatically fall with them. The sixth is that her contract claims also fail, and they don't work because there was never a signed contract in the first place. They say that the draft arguments were not executed, the conditions precedent weren't met, and even if a contract somehow existed, they didn't breach it and she didn't give them notice or a chance to cure it. The seventh argument is that her defamation and her false light claims don't hold up. They say that the statements weren't false, they were not made with malice, and they were protected by legal privilege. They also argue she doesn't even have standing for false light under New York law. They say, for argument 8, that conspiracy can't stand on its own. It needs an underlying tort. And since Wayfarer argues all other claims have failed or will fail, there's nothing left to conspire about. Their ninth argument is that there is no basis for liability against defendant Sarowitz. Sarowitz shouldn't be in this case at all. They say he wasn't involved in the conduct she complains about, and so therefore he can't be held liable just for being associated with that company. And the 10th and final argument is that damages must be limited or dismissed. Here they say that even if any part of her claim survived, her damages should be cut down. She lacks standing for lost profits or royalties, and the rest of her damages are too speculative to recover. As I had mentioned, this motion was filed on January 20th, and I believe the 22nd is when it was decided, and that's the day when all of those documents were unsealed. There's many of them. And there's a rundown of Wayfarer's motion for summary judgment. To reiterate, this is their best attempt to convince the judge that this case shouldn't make it anywhere near a jury. Their arguments, the defense side, Baldoni's side. Whether any of this sticks is entirely up to the court, but at least now you've seen exactly how it's framed and how they're trying to frame the law, the facts, and the narratives to shut this down early, or earlier than trial. I guess not early because we're a year into this, but you get what I mean. The judge hasn't ruled on the motion for summary judgment yet, but he has unsealed the documents, the required first step before he can issue the ruling. Today's video is a clean read-through. My goal is to release an enhanced version with exhibits shown on the screen as the motion describes them this upcoming week. The exhibits are messy. They involve celebrities and what they thought were private conversations, Sony executives and their impression of Lively bringing this case, things like that. Celebrity interactions are interesting because sometimes it feels like they are all out of touch, or maybe that's just me. If you want to follow how the judge rules on this, or if you want me to break down the next filing when it drops, make sure to leave me a comment and let me know that. I feel like it's already so saturated, YouTube, social media, whatever, with this case that I don't know that people want to hear anything else about it, but I felt like this would give a perspective as to why those documents were unsealed. And if you enjoy this sort of content, please subscribe to the channel. Be sure to like the video so that it helps people find it. I would really appreciate that. And let me know what you think of the case so far. Share